social clause is none of the WTO's business. Social clause is our business. We are responsible for international labor standards framing and formulation. So, this should not be touched by WTO, and it succeeded with the help of employers, workers and government representatives in the ILO to convince upon WTO that WTO should not infringe in the area of social clause and should not talk about placing social sanctions on countries which did not comply with social clauses, because there were more than one reason, economic reasons why they could not do so. But while taking this stand, ILO reviewed within itself that it has to do something to ensure that the complaints of the developed world do not one day become such a compulsion that they have to be used with the help of force, of sanction, to the detriment of the developing nations. So, what it did was that out of its by then 170 plus international labor conventions, it chose 8 core labor conventions and said they are the core labor standards. These 8 core labor conventions, whether or not they are ratified by any member state, would be complied by everybody. And they made an appeal to all the members that whether you ratify it or you do not ratify it, but you should embrace these 8 core labor standards, which in fact amounted to fundamental principles and rights at work. You can see 3 of them relate to child labor and bonded labor, 2 of them relate to the freedom of association and right to collective bargaining, 1 of them relates to equal pay for equal wages, and yet another one relates to discrimination in employment. 8 core labor standards. Now, international labor standards ratification is voluntary. It is one thing to say you must honor them and try to implement without ratification. It is another thing to say that you implement after ratification. Pakistan has been one of those countries which has been very ambitious in showing up that we want to ratify irrespective of the consequences, with the result that these 8 core labor standards, Pakistan is among 20% of the countries in Asia which have ratified all the 8 core labor standards. Which relates to freedom of association and child labor. Now, 2 emerging giants of the new economy is India and China, and they have not ratified. India has not ratified Article 87, ILO Convention 87 and 98 relating to freedom of association, and the ILO Convention relating to child labor. Same is China. It does not mean that they are not participating in the world economy. It does not mean they are not active on the economic platform. In fact, they have a lot of advantages. They are not being dragged in the ILO for non-compliance, because once you have ratified, you are under obligation, 1, to include the legislation in your national legislation, the standard in the national legislation, and number 2, you are questionable to the ILO's committee on each of those conventions as and when a complaint goes to those committees. And you are even liable to sanctions and punishments in case of your continuous refusal or failure to implement and comply with the ratified conventions. Having given you this background, some of you may ask, Why has Pakistan ratified so many conventions as compared to, say, I just took the name of United States. 5 or 6 conventions have been ratified. Reason, not that they are far behind, not that they don't respect human rights, not that they have any condemnation for labor welfare or labor laws or labor rights. No, not at all. They do maintain a very high standard of compliance with social clauses. But they found a very good reason not to do it. Anybody aware of the reason? United States ratifying only 5 or 6? Because under the Versailles Treaty, United States as a country cannot enter into any foreign treaty unless all the 50 states do not ratify that treaty. Okay? So, they say the ILO conventions could not get through all their 50 states. So, only those conventions which were adopted by all the 50 states could be ratified by the United States. Now, keep this scenario in mind. This is very important in the context of the concluding discussion that we are going to take place. We are going to do now. Now, I am coming to the post-devolution issue. What is devolution? It is a 18th Amendment hai kya? What exactly the 18th Amendment is? This 18th Amendment Act 2010, which was passed by the Parliament on 20th of April 2010, in fact made an amendment in the Constitution of 1973. Many amendments. And one of the many amendments that it made in the Constitution then existing to bring it in conformity with the Constitution of 1973 was that it eliminated Schedule 4 of the Constitution, the list which was known as concurrent list of legislation. There were 74 items in Schedule 4 of the Constitution which fell within the list of concurrent items of legislation, which meant under the 1973 Constitution, in respect of those 74 items, both the federal government and the provinces could do legislation. Those 43 items were eliminated, and out of those 43 items, item number 26, 27 and 28 related to labor, which means no legislation could be made by provinces in the area of labor welfare, labor conditions, provident fund, employers liability, workers compensation, health insurance, incidents including invalidity pension, old age pension, trade unions, industrial and labor disputes, and the setting up and carrying on of labor exchanges, employment information bureaus and training establishments. All these items omitted. The concurrent list therefore does not exist, which means in each of these areas provinces federal government ceases with the power to legislate. A period of 1 year has been given to ensure that the devolution is implemented, the devolution plan is implemented. And 1 more year would be available under the Constitution for taking such remedial steps which can address at discrepancies arising out of the